Okay. We are right at 12 o'clock. We're going to let people enter the attendees and we'll get started here in just a minute. Watching people come in. All right. Thank you everyone for joining us today. This is the Dallas Women Lawyers Association virtual CLE. We do these once a month and are grateful to everyone that is giving us their time and attention. Just a couple housekeeping items before we get started. At the end of the presentation, the CLE information will be in the chat. If you need it, we're going to submit for everybody, but take note of that. At the end, we will submit we will give you the information just in case. And check out the upcoming events for the Dallas Women Lawyers. We have a lot going on in the next few months. So visit our new website, follow us on social media, and participate as much as you can because we love putting on impactful events around the area, and we do all of this for you. So please join us and follow along on the journey with us. My name is Melissa Gray. I am the Vice President of Programming for the Dallas Women Lawyers. And today we have a wonderful panel of women from both New York and Dallas here, and they're going to talk about the latest in U.S. state data privacy laws, which is such a hot topic, definitely something that even, in every practice area should be something you keep updated on. So I'm glad these women are here. I'm going to introduce them one by one, and then they are going to take it away. First, we have partner Julia Jacobson out of the New York office. She's a partner at Squire, Patton, Boggs in the data privacy, cybersecurity, and digital assets practice. That is a mouthful, Julia. Lots of things there. She offers practical and tactical counsel on privacy and cybersecurity compliance strategies, data breach response, technology transactions, and marketing initiatives for national and multinational organizations. Also in the New York office is Sasha Kiosse. Did I get that right? Oh man, good. So Sasha is an associate. She splits her time between data privacy, cybersecurity, and digital assets practice and corporate practice. She advises national and international companies on data privacy, AI, and other emerging technologies in corporate matters. Also, such a huge relevant topic. So thank you for being here. And then our very own Dallasite, Elizabeth Spencer Berthiaume, thank you.
Yeah.
And she is also in the data privacy and security practice and focuses on data privacy and protection, cybersecurity, and data breach preparedness and response. So welcome, ladies. I am going to be quiet now and let you guys take it away.
Yeah, thanks so much, Melissa, for the great introduction. Very happy to be here. Let me share my screen and pull up the presentation. All right, I think we're all set up here. So once again, the topic of our presentation is the U.S. state data privacy laws. We're going to be focusing mostly on the Texas law and then kind of give you an overview of the other state laws that are in effect or coming into effect, just some compare and contrasting. And then towards the end, we're going to highlight some other kind of data-related laws that you should keep an eye on because they're also relevant and they don't quite overlap with the omnibus type laws that we're going to be focusing on for the majority of the presentation. So very happy to be here to discuss these points. And so once again, my name is Elizabeth. I have Sasha and Julia with me, my great colleagues. The QR code you'll see here, go to our LinkedIn. So if you'd like to connect with us, please do. We post blogs daily. We share, comment on items. I find that in the privacy space, the best way to keep on topic of all the changes, because something new happens every day, is to just be connected with other privacy pros. So follow us on LinkedIn. It'll be really nice and easy to gather some information, just keep in your back pocket as things kind of come up in your space. So Sasha, do you want to talk about anything else in the New York office? Anything you've been working on recently that's interesting?
Nothing in particular, but like Melissa said, I split my time between the data privacy group and the corporate group. So I get a chance to see things from both sides, more the corporate transaction side and then the counseling side in terms of data and data privacy.
Excellent. Julia, what about you?
Well, I don't have anything particular to add other than my primary focus is on large, complex, data-driven companies that are international. So both that have a lot of cross-border data transfer issues. Today, however, we will not be focusing on any of that big macro stuff, but a little bit more micro, as Elizabeth will explain in a minute. And we also just want to tell you about some breaking news, which I will talk about in a minute, which is the federal government just released another draft of the potential federal privacy law. And I'll explain a little later why that might matter for what we're going to talk about today. So with that,
Yeah.
Elizabeth, take it away.
Yeah, thanks, Julia. And like I said, there's always something new changing every day. There's a new topic. And so to get us started off with, I just wanted to provide a roadmap here. So done with introductions, we're going to set the stage for what the current data landscape looks like for omnibus privacy laws. Then we're going to get in the nuts and the bolts of the Texas law, which goes into effect July 1. So take notes. We'll go through the applicability so you can kind of orient your mind about how much you actually want to pay attention, I suppose. Then we're going to close it out with some comparing, contrasting, like I mentioned, with other state omnibus privacy laws, and then bring in the last bit of data-related laws as well. So we'll kick it off here. And I did want to start off the conversation with, why does it matter? Why are we here? And so, data is a huge, huge area. Lots of companies are trying to find out ways to monetize it. And in response to that, we have a lot of regulators who are taking notice of these data activities and are bringing enforcement actions, and legislators passing laws like the Texas law. Julie, anything else to add on this point?
Yes, I think it might be helpful if we gave everybody just a little bit of context about where we are in the evolution of privacy in the US. Mm-hmm. So for those of you who are relatively new to privacy, just here's a quick and dirty history lesson about privacy in the US, and you can also tune out if you already know all this. So privacy started as a tort. Well, it started with the Constitution, but the right of privacy, right of publicity, that was historically up until the past about 30 or 40 years where privacy was, where we got the right to privacy. It was the right to keep your life private, the right to keep your image, your voice, etc., all of that private. That evolved into as the technology advanced in data collection, the volume and velocity of data collection increased, sector-specific laws popped up. So health, financial, what's another good? Wiretapping is another good one, very hot right now. So we went sector specific, and everything was kind of sector specific until about 2018. And in 2018, what happened is a California real estate investor decided that he didn't like people selling his data. So he came along and said, hey, you're not going to sell my data. I'm going to propose a new law. And he proposed a law that was part of a ballot initiative. And the California legislature said, hey, no way, we're going to put a law in. And I will tell you that that law was so quickly drafted that it was amended like 4 times before the beginning of the next year. Meanwhile, the FTC was asserting its authority under its unfair and deceptive practices, what sometimes are called UDAP laws or consumer protection laws. It was assuming its right to be sort of the federal privacy enforcer in chief. And so we see Elizabeth has put on the slide, the FTC there. But before that, nobody was really thinking about the FTC as the regulator in chief. But part of what the FTC did is set up the privacy landscape to focus on consumers, because that's what their power was about, consumers, personal, family, and household use, not business to business. Elizabeth, I think, will explain in a little bit about the different scope in these laws. So then all of a sudden, there are 18, maybe 19 now, state privacy laws since 2018, June 2018. There have been June 2018, there have been 18 laws, a lot of 18s there. And I think what that has triggered is that's a pretty significant minority. So then in April, a second attempt at a federal privacy law was proposed. And it had a lot of things that made businesses go, oh my goodness. And it was, there was about a month of drafting and information seeking and lobbying, and a new version was released last night. So why does this matter? Because if that federal privacy law goes into effect, all of these state laws will be mostly preempted. So I think what we want to stress today is that there's this patchwork of state laws and there's this hover of federal privacy law. So just kind of setting the context for Elizabeth and Sasha to take you through one of the state laws, in fact, in probably all of the audience's home state of Texas. So I'll pass it on to you guys to take it away.
Yeah, thanks, Julia. I appreciate the context here and the hot off the presses. So we'll see if federal privacy law passes. I think that's what many businesses hope for, because as we'll get into in a minute, the complexity is pretty immense. So I'll hand it over to Sasha to take us through the current omnibus state privacy law landscape.
Thanks, Elizabeth. So far, there are 18 enacted state omnibus privacy laws, including the Texas Data Privacy and Security Act. 5 of these laws are already effective, and those are in California, Colorado, Connecticut, Virginia, and Utah, while the rest will be going into effect later in 2024, 2025, and 2026. The Texas privacy law is going into effect on July 1st of this year, as Elizabeth mentioned. In addition to these 18 state omnibus laws, there are also additional bills being considered in state legislatures, and we should expect additional states to enact their own omnibus privacy laws. So these 18 are not the end of the state laws. Most recently, the legislatures in Vermont and Minnesota passed their own privacy bills. So the total number of state privacy laws will likely rise to 20 within this month or the next month, if the Vermont and Minnesota governors do not veto these bills. And also, as Julia mentioned earlier, beyond the omnibus state privacy laws, there are other privacy and data-related laws on the federal and state level. For example, there are sector-specific laws, as Julia mentioned, including HIPAA, which many people are familiar with, and that governs entities like health insurers and medical service providers and protects health information. And then there's the Gramm-Leach-Bliley Act, or the GLBA, which imposes obligations on financial institutions and protects financial data. Other state laws also exist that govern specific types of data, including children's data, biometric information, and other health-related information. These additional laws will be briefly discussed towards the end of the presentation, so you can all get a sense of the legal landscape. Next slide, please. Next, I'll pass it back to Elizabeth to discuss certain important features and obligations under the Texas Data Privacy and Security Act.
Great, thanks so much, Sasha. So as y'all could see with that word vomit, all the states coming around federal laws, this is a very complex area to be involved in. It makes it exciting and fun, but just want to make you all aware of it, keep top of mind as you see data coming through your organization or for your clients. So with that, this is Texas oriented, so we're going to jump right into the Texas Privacy and Security Act, and I'm just going to call it Texas law versus the TDPSA. There's always alphabet soups for each of these laws, so Texas law just keeps it a lot more simple. So the basics here are, like I said, July 1 is your effective date. That's something to keep in mind. It's fast approaching compliance. Developing a compliance program for these laws does take some time and a lot of kind of internal resources. We'll get into that a little bit later. Some key features here are there's no private right of action, which is really helpful for companies, and there's a 30-day cure period. So what does that mean? If you get a request from Attorney General or a note from them, you have 30 days to basically remediate deficiencies. And I will say 30 days is a short time period to implement some of these requirements under the law. So just keep that in mind. It's helpful, but some things they do take several months to take care of and get your house in order. And so the most important piece I would say on this slide is the applicability, and I'll be going into it a little bit more detail in the next slide. But basically, if you are a Texas company who processes personal data of Texas residents, or rather not even a Texas company, you could be a company based anywhere, but if you're doing business in Texas, you process personal data of Texas residents. And so processing is a very broad term. So if you touch the data, if you play with it, if you store it, if it's anywhere in your systems, this law brings you into scope. Notably, there is no revenue requirement or revenue threshold or a number of records threshold. So it doesn't matter how much money you make. It doesn't matter if you only have one Texas resident information in your storage facility. That's enough to bring you to scope of the law. Now, the only kind of saving grace here is if you are a small business as defined by the SBA, then you kind of have more limited requirements here. And specifically only if you're selling sensitive data. So we'll get into that in a second. This lovely chart here on the side kind of breaks up the Texas law into big chunks to help you understand it a little bit better. And this will also follow along the rest of the slides that we're going to talk through briefly. So privacy policies, consumer rights request, managing cookies, data protection assessments, contracting. Those are kind of the big topic areas within the law. And so we'll be diving into that in just a few minutes. Now, this slide, I'm not going to go into a lot of detail on. This is basically a decision tree, if you will, to determine whether your client is subject to the Texas law. So is it personal data of Texas consumers? If you're primarily business to business or HR data, that's out of scope. Once again, small business, special exception there, or limited compliance requirements. And then even if you are subject to the Texas law is equipped with certain exemptions within it. So there's data level exemptions and entity level exemptions. So I want to call your attention to bullet point number 4, the last bullet, data level exemptions. That's really important. So if you DWLA regulated data, that data is out of scope. HIPAA regulated data, that data is out of scope. FCRA data, out of scope. Entity level exemptions are also really important. So if you're a nonprofit in Texas, you're out of scope. Don't have to worry about it. Higher education institution, out of scope. Don't have to worry about it. So these last 2 bullets under number 4 will be key for you to understand. You know what? Even if you have personal data of Texas residents, Texas consumers, there are still exemptions that apply. So be aware of those, think through those. There are some buckets of data that are likely somewhere within your processes that might be subject to the law. So that takes some detailed analysis. So just keep this and save it. You'll find that a lot of these slides as we go through the presentation do have a lot of information. So save these as a resource. We'll be sending out the slides afterwards. So keep it saved on your desktop and just refer back to it if you have a question or you want to dig more details into it. The next thing that I do want to mention with this slide, I did underline some of the defined terms within the law, and we have an appendix at the end of the slide that dives into those definitions in more detail. I will say that the definition of personal data under the Texas law is extremely broad. It includes things like IP address, mobile identifiers. So not just name, not just email address as people would typically think. It is a lot more broad. If you assign somebody a customer number and it's just a random 6-digit number that's randomly picked, that 6-digit number still counts as personal data under the law. So all of these requirements apply to that type of data. Now, a couple exceptions to personal data. Publicly available information is carved out. You have to do some analysis of what that meets the publicly available definition. So do look into that. Then the other carve out is de-identified data. Once again, that's a defined term. So you have to look at the data and see if it meets the term for de-identified. And then within the Texas law, it has kind of a special language for pseudonymized data. Basically, if you have pseudonymized data and if you keep it separate from other types of data that would help you identify that person, then it brings into the definition of personal data. So conversely, if you keep your pseudonymized data separate with technical and organizational separation mechanisms internally, then that carves out that pseudonymized data. So once again, that's in a definition in the appendix. So be sure to look into that because I think a lot of companies could take advantage of the pseudonymized data exception here to personal data.
Elizabeth, we should encourage everybody to ask questions. I meant to say that earlier. Please ask questions as we're going.
Yes, please put questions in the chat. I know a lot of this may be kind of new concepts, or maybe you're an experienced privacy pro and you want to dig into some details, feel free to put them in there. Julia is going to be monitoring that for us and interject as we go through these slides. Now, this next slide, I'm not going to go into too much detail on it. I will say that controllers of data. So a controller is someone who determines the purpose and means and processing of the data. So they're the ones who decide how data is shared, what it's used for, and they typically employ processors to process data on their behalf. So they're the ones giving the instruction and have ultimate control over the data. And so these controllers have certain responsibilities. Data minimization, data protection are two of the major ones. And then on top of that, they have certain requirements. So one of the key requirements here that I want to focus in on is when a controller collects data, they have to disclose to consumers why they're collecting the data, like what is the purpose for it. And so that disclosure will be in the privacy policy generally. And so once you've disclosed that purpose, there are limitations of how you can use that data. You can't use it for purposes that are unnecessary or incompatible to that first purpose that you collected it for. So I have an example here. So if you have a privacy policy that says, hey, we collect your email address only to service your account. That's the only purpose we use that email address for. But your business team says, hey, I want to use email addresses to send marketing emails. Well, you only have consent for servicing the account. So you need to go back through and attain consent for the additional purpose, which is using those emails for marketing. So that is a very kind of simplistic review of it. These things could get very complicated because business use cases are very complicated, but basically the purpose that you get consent for, you can't do anything outside of that without additional consent. So that's the first kind of main obligation. I think of it as like a secondary use consent, personally, if that's helpful. And then the next piece is if you're collecting or you want to collect sensitive data, you need to have consent to do that on the front end. You can't just collect it on your own and provide implied consent. You can't just have implied consent for it. You have to get more affirmative consent for that sensitive data processing. And so sensitive data is a defined term, and it has basic things like race, ethnicity, sexuality, and precise geolocation, which is being able to locate an individual within a 750-foot radius is the definition there. So you need to have specific consent for sensitive data use cases. And so I have this box here talking about consent. I'm sure we could have an entire different presentation of what consent means and under what circumstances. It's very fact specific and use case specific. So I'm not going to get too much detail there, but I have that definition, kind of give you a flavor of what that consent can look like. And then here, I'm going to pass on this slide over to Sasha, and she's going to dive into those privacy notice requirements, which, like I said, what you put in your privacy notice is very important because those are your listed purposes. And if you're doing anything outside of those purposes, that's when you need that additional consent.
Yeah, so as Elizabeth mentioned, this is one of the obligations for controllers. And I want to note also that this obligation exists in the other state privacy laws as well, albeit with some differences in content and other various differences, but every state law has a privacy notice requirement. These requirements come from the duty of transparency, which generally is the idea that consumers should know and understand the data processing practices of a company and the purposes for which their personal data is collected and used. So in Texas, the law provides for the content requirements that you see on the screen here. And I will briefly go over them and provide some examples. So in these privacy notices, controllers must disclose the categories of personal data processed. These categories may include broad personal data, like Elizabeth mentioned, including online identifiers and numbers that you may assign, and may also include other information like government ID numbers, other identifiers like name and address, biometric information, other internet usage information, and geolocation, just to name a few. Also required is the purpose for processing that personal data. Purposes also may include advertising, providing a product or service that a consumer requested, or research and development. And again, this is not an exhaustive list by any means, but just a few examples. Next are categories of personal data shared with third parties and also categories of third parties with whom data is shared. Third parties are usually other businesses that are not the controller, not the processor, and not the affiliate of the business. And they may include entities that provide services for the controller. It could be advertisers. There are many third parties with whom a company may share personal data. Also, controllers must describe how consumers can exercise their rights under the Texas law, and we'll get into the rights on a future slide, and the methods through which requests may be submitted. Oftentimes, companies will have an online portal where consumers can request certain rights that they have under the law, and that way the company can collect kind of all of the requests and get through them that way. And finally, there's a required disclosure if the controller sells or processes personal data for targeted advertising, so for sale and targeted advertising. And in that case, you have to just disclose in the privacy notice that you do that, and also describe how a consumer can exercise opt-out rights for those.
We have a question. Yay! Thanks for sending questions. It makes us know you're out there. So somebody had asked, do you need to have a privacy notice for every client instance where you're processing data? So I think you mean you might, that to me sounds like this particular questioner comes from a technology company. So you're thinking, does every customer have to see a privacy notice? And the answer is, it depends, which is the most annoying answer a lawyer give you. But so the laws that we're talking about today, except for California, are primarily focused on consumers, right? So personal, family, and household use, if we're talking about what is strictly required under the laws that we're talking about. Now, the FTC has said that you should generally have a notice when you are collecting personal information from anybody, right? Because they have a right to know what's happening to their information. And then there is a California law and a similar but slightly less detailed law in Delaware that requires a notice when you're collecting personal information online. So the short answer is it's going to depend on what your business does and how much personal data you are collecting, because you said processing data, so that could be personal data or just regular old data. But I hope that sort of answers your question. And if not, please send us another one.
We can move on to the next slide. So further disclosure requirements under Texas, Texas also provides these disclosures that you see on the screen. So if you are selling sensitive personal data or selling biometric data, the Texas law provides that you must provide this disclosure. They provide the text for the disclosure. And this disclosure must be posted in the same location and same manner as the privacy notice. So there's some ambiguity, some disagreement about whether this text should be in the notice or elsewhere, like the footer of a website where the link to the privacy notice is found. Texas is one of the only states that actually provides a disclosure like this, where they provide the text of the disclosure. The privacy law in Florida has a similar disclosure requirement for sale of sensitive data and biometric data. Next, Elizabeth will take it back to discuss the consumer rights available under Texas law.
Yeah, thanks, Sasha. And to kind of jump on top of this extra disclosure requirement, I think clever minds disagree, like she said, about whether or not, this notice we may sell goes in the privacy policy itself or in the footer or maybe another location at the point of collection. I think it's really fact dependent. And I think that, if depends on risk tolerance, depends on what type of data you're collecting. I think certain types of data have more focus by the regulators. So sensitive data, biometrics, children, I think in those cases that are considered more high risk, you should consider maybe providing little heightened notice instead of just burying it in the privacy policy. So just wanted to kind of add that in there. And with respect to the consumer rights, so I have this listed here. Texas law aligns pretty closely with the other state laws. So a right to correct, delete, data portability. So receiving a copy of the data that the consumer has provided to you. So you have to provide that in a portable format. Confirmation of processing. So do you process their personal data, right to access the personal data that you have about them. So that kind of lines under the data portability right too. So typically companies kind of lump those two rights together and then just put it out. Here's a copy of your data. Have fun. This is everything that we have about you that you provided, yada, yada, yada. Right to appeal. So for example, if someone submits a request to delete and there's an exception to delete that applies, you can say, hey, we didn't process your request to delete for XYZ reasons. If you don't agree, you could submit a right to appeal, and then that starts a new process where everything gets looked at again. So that's something that's to take note of. Additional consumer rights are rights to opt out of certain processing. So the sale of data is a big one. And I did want to mention, and this is once again in the appendix, the description of sale is very broad. It's not just for monetary consideration. It's for monetary or other valuable consideration. And so what does that mean? In the privacy context, basically, it's any transfer of data that is not to a service provider is essentially what it is, service provider or vendor. Because otherwise, why would you be sharing the data? So the idea is unless you can call a data recipient a processor, then it's a sale. And so we'll get into more details about some processor requirements later, but something to take note of. It is very broad. Next thing, opting out of targeted advertising. I think we all know what targeted advertising is. Commonly, data is collected through website cookies and pixels, and we'll dig into CMPs and GPC signals a little bit later on. And then the last one is opting out of profiling for decisions to produce a legal or similarly significant effect. Mouthful, what does that mean? We have the profiling definition a little bit later on. Basically, it's sort of kind of an automated process that makes a decision about an individual that affects significant portions of their life. So we're talking housing, we're talking financial services, access to utilities, things of that nature. And then the law has a host of response requirements. It kind of goes into a lot of detail for how you're supposed to intake the response, how you're supposed to respond to the consumers, the content of the templates. You have specific timelines. So you have 45 days to respond, and you can extend it for another 45 days under certain circumstances. You have to do identity authentication, agent verification, and then, of course, you have to effectuate the request, which I think is a big lift for a lot of these companies because they have to figure out, okay, where is this data? Where do I need to look to delete it? Do I even have to delete it? And then, of course, passing down these requests to processors. So if you have a processor that holds your data on your behalf, you have to say, hey, I got a request to delete. Can you delete this on my behalf? So you roll it down to the processor, as an example. And we could spend an entire probably half day talking about the details of intaking and processing consumer rights requests, but I just wanted to put this slide here for information, just a quick touch on it. This is a big area in our space. It gets complicated very quickly. And so once again, cookie management. So like I said, those opt-out requirements for sale and targeted advertising in the cookie space, a lot of cookies, pixels, tracking technologies, their use of that data falls under the definition of sale or targeted advertising under the law. So how do you effectuate or how do you provide notice to consumers of what's happening with the cookies? How do you effectuate an opt-out? How do you record it? And the answer is using a consent management platform. You won't find the term consent management platform in the Texas law or most of the laws generally. This is just a tool to effectuate that. So these are vendors like OneTrust, Osano, Kiosse. They're out there. They'll help you create pop-ups like cookie banners or cookie preference setters to provide the adequate notice to consumers, and then the opt-out mechanism. That way you can stop a cookie from firing that performs sales or targeted advertising. So picking a vendor is very important in this space. You can get complex or simple ones depending on your business use case. And then implementing the vendor is usually a pretty heavy lift. Setting that up because it has to be configured specific to your business and the type of cookies on your website. So categorizing your cookies and pixels is key. sale, targeted advertising? Is it a processor, which there's no opt-out right for processors? So you'd have to categorize those cookies and have certain toggles for opt-out or not opt-out, or you can't opt out of this one. So it gets pretty complicated. And then once again, crafting the appropriate disclosure language that fits within the cookie banner or the preference center. Just throwing that out there. GPC signals, global privacy control. So I'm going to touch on this rather quickly as well. So this is essentially a browser add-on that consumers can add onto their Google Chrome instance, if you will. GPC is a type of an opt-out signal. So I have the link here. It's very common. So you download that, add it to your browser, and when a user visits your website and they have the signal firing, that is an automatic communication saying, opt me out of sale targeted advertising. So if the user is sending out the signal, you've got to have a way to intake, to recognize, hey, that signal is GPC. Hey, that means they want to opt out, and then opt them out of the cookies. And once again, that's typically done using a CMP. They have toggles in the back that you flip on and off to help enable the GPC signal. And so it acts as an automatic opt-out where a user doesn't have to do anything else, which is simple from a consumer perspective. And it gets more complicated if there's anyone who's listening in who's in the ad tech space. I think that, that's a whole separate conversation for how ad tech companies, advertisers, publishers manage this, because it gets complicated very quickly as well. And I'll hand this next section over to Sasha to talk about data protection assessments, which is also a requirement under the Texas law.
Yeah, so in Texas and most of the other state privacy laws, controllers must conduct and document data protection assessments when engaging in particular data processing that is considered especially risky to consumers. Data protection assessments are essentially risk assessments that require controllers to weigh the benefits and risks of the activity that they're engaging in as mitigated by any safeguards that are implemented or may be implemented. So the activities that trigger this requirement are targeted advertising, sale of personal data, profiling that presents certain foreseeable risks, and we have those risks below there starred, and processing sensitive data. This list, I want to note, is open-ended. The last activity that's noted, the last bullet, is other activities presenting a heightened risk of harm. And heightened risk of harm is not defined, so it's kind of an open-ended prompt, and it's an open-ended assessment for the controller to decide if a processing activity is particularly risky. An assessment will also be required. So to keep up with this requirement, it is helpful to do some work on the back end to create a plan should such assessments be necessary. This may include some thought about which departments within the company are involved in the data processing and will have to be involved in the risk assessment, and even who within the company will be in charge of completing these assessments and ensuring that they are accurate. It is also important to know information about data practices, including which types of data are collected, sold, and disclosed, and where such data is collected. Also want to mention that these risk assessments must be disclosed to the Texas Attorney General upon request. So once they are disclosed to the Attorney General, they will be confidential and exempt from public disclosure, but you should know that these assessments may be viewed by regulators, so it's important to take them seriously if these processing activities are being taken on. And next, we'll move on to contracting and audit requirements. I'll hand it over to Elizabeth and Julia to comment on these.
Yeah, thanks, Sasha, and thanks for the rundown of the DPAs. I think that's an entirely new process that most companies are not familiar with. So understanding that, that document is going to be looked at by regulators. If they ask for it, you've got to produce it. So being sure that it's crafted carefully is really important. So onto contracting and audit requirements. So the Texas law has requirements. Certain language have to be included in the agreements between controllers and processors, basically outlining how the data is going to be processed, why is it being processed, the type of data. And so you have to get really specific There tend to be like addenda at the end or exhibits. They kind of list out the specific data elements, duration of processing, which is typically the term of the agreement, and then rights and obligations of the parties. So who's responsible if there's data breach, data security requirements, things of that nature. And then it also provides an audit requirement, which I've identified here under subsection 6C and D. So basically, a controller has the responsibility to perform a review of their processor. So they've got to ask some questions like, tell me about your data privacy practices. Are you complying with the privacy laws? Because processors still have to handle data appropriately. And then, of course, there's an additional assessor requirement here. So either the processor can have its own assessor do a review of its practices, or the controller can have their assessor do it for them. So there's a couple of different ways to slice that up. And I think that's something that a lot of companies, in my experience, struggle with. You know, how do we perform an audit, especially smaller companies or companies who are not typically in the regulated industry? They don't have a sort of a vendor management program where this is kind of baked in, where they're digging into the details of their processor. So this is something that, you know, should be focused on for companies who are new to this space, who are new to being regulated, if you will. So focus in on that. And once again, I think that we can have long conversations about the extent of the audit requirement here and the DPA language. And so, Julie, I want to throw a question to you out. In your experience in negotiating DPAs, are there any kind of common kind of sticking points between clients and their processors or other parties that, you know, just have a lot of issues, or people, you know, they just get stuck, negotiation points?
Well, a couple of things, sort of taking just one step back, is the data processing requirements under Texas don't add anything materially new for those companies that already have a DPA that might comply with the other state laws, or under GDPR, the General Data Protection Regulation, or the UK equivalent. So if you've already got a bunch of DPAs out there, nothing earth-shattering to require immediate changes. I think that's one important note. Now, again, it's going to depend on what's in your DPA and et cetera, but assuming you have a generally compliant one. In terms of negotiation, I always say it depends on which hat I'm wearing. Am I wearing the hat of representing a controller, or am I wearing the hat representing the processor? And when I'm wearing the hat of the processor, we generally try to have our DPA stick exactly to the law. And we use that as our negotiating. Look, we're not doing extra, right? We'll do what the law requires. We're not doing extra. Now, if you're a controller, you want to wedge other requirements in there. Like, for example, you might want to put in unlimited liability provision for a breach of a DPA. You might want to carve it out from exclusions to liability caps. So a lot of coordination with an underlying agreement comes up with both controllers and processors. Controllers typically want more and may have a difficult time arguing for it if a processor says, I'm just going to do what the law requires. Then it becomes just a battle of market power. And my other experience is the bigger the processor, the less likely you will get any change, which is true for every technology contract in the entire universe. And the final thing I think is important to add is that this is a controller to processor relationship, but it is not the only potential relationship. It could be what we'd call, let's just for simplicity, call a controller to a controller. So one business is giving data to another business, and the privacy laws don't say, this particular one doesn't say, thou shalt have a similar contract. And so a lot of clients struggle with that because they want to put limitations on the receiving controllers use of the personal data that are consistent with any downstream promises they may have made to data subjects and privacy policies. And the receiving controller says, hey, no way, you give it to me, it's mine to do business with. So for a controller to control a relationship that's not a controller to processor relationship, your primary arguments will be contractual rather than statutory. Hopefully that makes sense. And if not, use that Q&A tool and we'll refine. Does that help, Elizabeth?
Yes, perfect. Thanks for providing more color on this, Julia. I'll take this next slide too. So we talked about the definition of profiling earlier, and so I've have this put up here. So automated processing performed on data, solely automated processing. So if a person is out of the picture, then it's profiling. If there's a person involved, then you don't have to worry about this. But there's an opt-out requirement under the Texas law. So I have heard in conversations with other attorneys and house folks, other people who are not as familiar with privacy laws, they say profiling, oh, it's automated, solely automated. That must mean AI as well. Does that mean that I need to provide an opt-out for artificial intelligence activities? And the answer to that question is, it depends on what's going on. So you can have a profiling activity that utilizes AI, or you can have a profiling activity that doesn't. And so, Julia, do you have any other kind of comments on the profiling versus AI conversation?
Sure, happy to chime in here. So I think when you're talking about profiling, it's important to remember it's a processing operation. It's something that is done on personal data. AI is a kind of technology. It's not a processing operation. So you think of AI might result in profiling, but it is not, when you talk about AI, it's important to remember that you're talking about technology, a means of processing, not a processing activity. And I think all of these concepts get conflated because of the recent popularity since approximately November 22nd, when ChatGPT was released and sort of changed everything. I think it's the new AI craze. I think it's important just to remember that it is technology. It's applications. It's not a processing operation per se. So I think that's when we think about, is it artificial intelligence? Well, it's not a processing operation. Artificial intelligence, input, output, something happened in between. Whereas profiling is something here, as it says on the slide, that produces a decision that produces a legal or similarly significant effect, which could be something that AI does, but isn't necessarily something that AI does. So I hope that explains it.
Excellent. Yes, Julia.
Use those Q&As.
Yes. Thank you so much. Julia is our AI guru and expert, so wanted to be sure we get her take on that point too. So wrapping up our discussion of the Texas law specifically, I did want to throw the slide up here for how you can get started. If you think it applies to you, go through that checklist that I had earlier in the slide deck. At the end of it, be like, yeah, I'm pretty sure, this is something I need to be concerned with. July 1 is the deadline. How do you get started? So first of all, you need to build out a team. If you don't already have privacy team built out, something in-house already, even compliance related, that's the first point. I will say that in my experience working with clients and being in-house actually, that having C-suite and executive level support for implementing a privacy program is key, because privacy touches anywhere in the business that has data, which is every business unit basically. So you've got to have that top-down support to push down initiatives, also to get funds, because having a CMP vendor, that's going to cost them. Bringing in an outside counsel to kind of go through some legal analysis is going to cost them dollars as well. So having that top-down support is crucial. Always get your business team involved. Utilize privacy analysts and managers. They don't always have to be done by lawyers. A lot of these activities you can manage with kind of privacy analysts and business level folks. So be sure to leverage that so you don't overburden already kind of a complex and busy legal team. After you get your team kind of set up and outlined, data mapping and inventory, that's probably the biggest one. That should be a theme throughout these presentation, is know what data you have, what it does, where it is, and where it goes. And I think that is a challenge for many organizations, is mapping it out and then keeping your arms around it. Data sprawl is a huge problem because even after you do the initial data map and inventory, business teams are going to do what they do, and they may not ask you and let you know, hey, update your table, hey, update, whatever vendor you use for the inventory or the map. That slips through the cracks all the time. So having strong processes and procedures and training to be sure that you're keeping an eye on what's happening with your data, even go forward, because once again, that leads back to your privacy policy. That leads back to complying with consumer rights requests, performing the DPAs, which, like we remind you, are going to be reviewable by a regulator. So all that's important. And so the last tip that I have in this is kind of focusing on outside in. So prioritizing your privacy policies, your CMP, your GPC, everything that an external person can view very easily, and then focus on your internal background processes and procedures. Because guess what? I can go on a website, see a privacy policy, see the effective date the last time was updated, and I will immediately know whether or not that's a good privacy policy. And even if it was updated recently, 30-second review, I can pick out gaps immediately. So it's very easy to find issues.
And there are AI tools out there doing that very thing, hunting around for non-compliant privacy policies. So as Elizabeth said, a top-down, bottom-up, and outside-in kind of approach to privacy compliance is really important, because the stuff that somebody can see is easy for them to, a regulator can see, is easy for them to complain about.
Exactly. And once they've got you in their sights, they can ask more questions, and then they'll find all the other kind of gaps on the back end. So just keep that in mind. And so here we're going to do a quick run through some of the other state omnibus privacy laws, so you can kind of see how Texas compares just mentally, because the space is very complex and there's nuances. So even though you may be compliant with Texas, if you think there's another state that might be in scope, bring that in. And so I'm going to hand this over to Sasha for her to kind of walk us through at a high level. I know we've got about 9 minutes or so left. Once again, insert questions in the Q&A and we'll fit those in.
Yeah, so I won't go over these in detail, and obviously these aren't all the state laws. There are 18 of them, but these next few slides will kind of show a few differences between the states. So we already discussed the applicability under Texas law, how you know which companies are in scope. And I just want to point out on this slide that it's important to look at each individual law to see if a company is subject to that law. So here I want to point out that the Maryland framework for applicability is kind of a common one among the states. So it's businesses that do business in the state and then either process the personal data of a certain number of consumers or process the personal data of a fewer number of consumers and derive a certain percentage of revenue from the sale of personal data. So that's kind of a common approach under Maryland. Also want to point out that Florida, for example, as we said earlier, Texas is kind of has a broad applicability because there's no revenue or processing requirement. And I want to compare that to Florida, which it has a narrow applicability, partly because it only applies to companies that make over $1 billion in revenue, and also either have to derive at least 50% of their revenue from sale of personal data, or operate a smart speaker and voice command service or an app store. So that only applies to a few companies. That doesn't apply to many. And then California is another example of a different approach. California was the first law, so they kind of created this framework. And then on this slide, I also want to point out, as Elizabeth said earlier, nonprofits are exempt under Texas law. Nonprofits are exempt under most of the laws. But in Maryland, for example, and this is true in a few of the other laws, only certain nonprofits are exempt. So in Maryland, it's only nonprofits that assist law enforcement in insurance crimes and first responders when there's a disaster. Pretty much. And also human resources data, which is pretty much employment data, is exempt, is not in scope under most of the laws. under actually all of the laws except for California, and same thing with business-to-business data. We can move on, Elizabeth, to the next one. So here, again, comparing privacy policy requirements, we already went over Texas. And I want to point out here that every other law on this page, they have the same requirements as Texas, plus additional content requirements. So I just want to note here that, again, it's important to look at the particular law because you might be complying with Texas and including most of the content that is required under the other laws. But you might have to make additions if another law applies. Yeah, next slide. And same thing here. So the rights that Texas provides are pretty common throughout all of the privacy laws. But again, there are some differences. Here, for example, Oregon provides a right where a consumer can obtain a list of specific third parties and not just categories of third parties that receive personal data. So that is a notable difference and requires a little bit more work to incorporate that into the privacy notice. And also another difference here, Maryland provides for the opt-out of profiling right, as do most states, and as does Texas. But in Maryland, it's only for profiling in furtherance of solely automated decisions. So it's a more narrow right because in Texas, it doesn't have to be solely automated. It could be partly automated, partly human run, but in Maryland, it's for solely automated decisions.
And I just want to add too, Oregon goes into effect on July 1 as well. So if that's something potentially in scope for you, that additional categories or listing specific third parties who receive personal data, that's a big lift.
Yeah. And then we can move on. I think Elizabeth will discuss sale briefly.
Yeah, the sale concepts here are very similar from Texas across other states. I will say that under California, they do have specific sale exclusions within the definition. So do take note of that. So consumer directed. So if there's an activity that consumer says, hey, yeah, do that. And if it would otherwise be a sale, then you don't have to provide an opt-out right for that. So that's something to take note. And that exists in a couple of other areas. The definition of sale under Texas does not include transfers to processors or third parties who are performing a service requested by the consumer. It doesn't include affiliates. I will say under California, certain affiliate sharing can be considered a sale depending on how your affiliates are structured. And so that's kind of a detailed analysis that has to be done. I'll move on to the next slide and hand it back over to Sasha.
Yeah, so as Elizabeth mentioned earlier, Texas has a definition for sensitive personal information, as do the other state laws. In Texas, it includes racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexuality, citizenship or immigration status, genetic or biometric data, personal data from a child under age 13, and precise geolocation. All of the other states listed here have the same categories under sensitive personal information with additional categories as well. So California has a bunch, including government ID numbers and financial account logins, stuff like that, philosophical beliefs and union membership. And Colorado, for example, also has mental or physical health diagnosis, but they include condition as well. So it's a little bit broader there. Yeah, so with sensitive data, the state laws have different requirements. So in Texas, consumers have to opt in. So they have to consent prior to collection of sensitive data. That's also true in Colorado. In California, there's the right to opt out and right to limit sensitive data processing. And then Maryland is kind of an outlier among the state laws, but they have a pretty strict requirement that processing is only required when strictly necessary, and sale of sensitive data is generally not allowed. And we can move on to the next slide. So enforcement, again, so all of these laws that are included here, they all provide a cure period, 30 days in Texas and California, and 60 days in Tennessee and Montana. But it's important to look into the specific details. So for example, in California, the cure is before the private right of action, which is limited only to data breaches. So this is something else to consider when looking at these laws. And I think we're out of time, but this can all be referenced in the PowerPoint as well.
Yeah, excellent. And so this last few sections is just us talking about, the other areas of privacy data related laws that exist. So feel free to flip through those. So it's not just the omnibus privacy laws that cover the data generally, but they have specific ones for genetic information, children's data, even AI recently came out. And what state was that? Was that Colorado? I forget.
Colorado.
Yeah, Colorado just passed a new AI law. So this is just the world of other privacy laws to just be considerate of. And then we do have some suggestions for how you can develop your compliance program within all these like complex patchwork of privacy and data related laws. So lastly, shameless plug here. This is a link to our blog. Please subscribe. Like I said, data privacy law, data related law, technology, AI law changes almost daily. And so we do our best to, keep content up to date and relevant for our readers, clients, potential clients. A great way to be apprised of what's coming. So please feel free to sign up, link to that there, to Privacy World blog if you'd rather Google that instead. But thank you all so much for tuning in. It's been a great pleasure. Thank you, Sasha and Julia, for participating as well. And I'll hand it back to Melissa now.
That was so relevant and so much good information. Feel free, everyone, subscribe to the blog. I know I will. Data map for sure is going on my schedule of things for clients to get in front of early. So thank you, ladies, for your time today. Attendees, the information is now in the chat. And if you have specific questions, I know these ladies would make themselves available, for additional consults if people have more of a need. So thanks to each of you. And have a wonderful afternoon.
Yes, thanks so much. Y'all have a good rest of your day.